Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about Gladue Reports and sentencing. Cases that should have gone to the Supreme Court of Canada, but didn't. William Turner was charged with some offenses related to an assault and uttering threats, and he was sentenced to a custodial sentence of imprisonment. At his sentencing hearing, he presented a Gladue report indicating his personal history as an Indigenous person, the history of his family, and his prospects for rehabilitation. The Gladue report was considered, but was not put much emphasis on by the sentencing judge, was the question of whether or not these forward-thinking considerations, including prospects for rehabilitation, options for treatment, and community activity in the future, were available to him as something that he could do with a community-based sentence or with a shorter period of incarceration. Unfortunately, Mr. Turner was then sentenced to a lengthy period of imprisonment. Mr. Turner appealed, and the case went to the Supreme Court of Canada, which denied leave. The Supreme Court of Canada missed the opportunity to decide a very important issue when it comes to Gladue reports. It's not just about what somebody's been through and all of the very tragic circumstances that have led to them coming before the court that should be taken into account when crafting an appropriate sentence, but also where their community is going and where they're able to go within the Indigenous community as far as accessing supports, treatments, community activities, cultural activities, participating in your heritage and your culture, which studies have consistently shown decreases the probability that people are going to be involved in criminal activity in the first place. And no section of the criminal code prevents judges from taking into account the forward-thinking aspects of Gladue reports, but consistently they're often given less weight than the past activities and actions mentioned in Gladue reports. And this case would have been an important opportunity for the Supreme Court of Canada to recognize that sentencing is not just about what has happened to bring somebody before the court, but also their prospects for rehabilitation within the lens of those Gladue factors and Indigenous individuals. And unfortunately, Mr. Turner's case was a missed opportunity for the Supreme Court of Canada to really emphasize the significance of that forward-thinking activity in Gladue reports, which should have as much weight, in my view, as all of the past information that has been provided there. Hopefully the Supreme Court of Canada does take the opportunity to consider these issues in the future and does give some guidance to judges in how to look at forward and future information in Gladue reports in conjunction with the information about the circumstances of the offender that brought them before the court. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.